Welcome.
Good morning, may it please the court, and I would like to reserve 5 minutes for 5 minutes. This is the second tier review of a decision that originally started here in Tampa. The code enforcement level was appealed to the circuit court, its appellate division, and the circuit court applied the wrong law.
Was Vickery correctly decided?
Vickery was correctly decided.
All law, was it binding on the trial court in this case, even though it's on the first DCA?
Yes, it is, but it was fundamentally misinterpreted by the circuit court, and this is how. Vickery said, and it started the entire decision was nothing but reading the dictionary, common usage, plain words. Then it says, because of the facts of the case, the statute applies in this case in Pensacola because just because somebody's not living in the house, it still applies.
When you said it was zone commercial.
In Pensacola, it was actually zone residential, but unoccupied. And so they said this statute obviously applies. What it says is residential land, if it's zone residential, it applies. It set a floor for the statute. I'm sorry.
Line was thrown out and one was
In our case, Your Honor, in Vickery, it was essentially one fine on a couple that had an unoccupied house. And what Vickery said, what the court said was, they set a floor. They said, this is zone property residential. So obviously the statute would apply in that instance. It's not the ceiling. And so what the circuit court did in Tampa is they said, well, guess what? This property, Gandy, it's not zone residential, which there's an argument about, but the truth is they said it's not zone residential. So Vickery, because of Vickery, it doesn't apply. That's not what Vickery said. That didn't give the roof, it gave the ceiling of what that statute meant. It set the floor. It said if it's zone residential, obviously it's going to apply. But based on the very broad, open-ended, purposeful, by the way, the legislature left the terms undefined purposely.
well, let me ask you, in general, commercial property cannot be used to sleep. Is that true or false?
Generally, no.
And what's the fact in this case?
In fact, in this case, that this property entirely was used residentially. Never been used commercially, not even an instance. I would argue that this statute would mean even if it was more dominant residential, the statute would apply. But in this case, quite literally,
And the city never disputed that.
never disputed that it was commercial property. They just pointed to the zoning and said, look, it says CG in the LDRs, the land development regulations, it's commercial. That essentially was their argument.
And ignore all the mobile homes that have been there forever.
Quite literally ignore the mobile homes that have been there forever, and also literally, and you'll see this in the transcript, which is in the appendix, the people who are living there right now, there were people moving because they knew that it was transferring ownership. And they're saying, yeah, well, they're transient people. They're not permanent. They're not, part of the homes that these people cross the way.
Zone to run a mobile home park.
The original zoning said commercial, but allowed.
Grandfathered in, so they did according to the rules at that time.
Yes, Your Honor.
Well,
And
let me ask you one other question. The landscaper comes along, homes, I don't like that tree, it's disease, cut it down. Is the landscaper supposed to go to the zoning map and check out the zoning, or does he say, people living here, I can cut that down, I don't need a permit?
under the original statute, which of course is the statute issue in this case, not the one that was later amended, that arborist, that landscaper had full discretion.
And nobody approached him from the city, said, show me the evidence that you've had someone look, that these trees are diseased.
So under the statute, they were not supposed to, but they did anyway. So the way the statute's written, the original 163045 from 2019 was so open-ended, the city essentially wasn't allowed to require any more information other than, do you have a document? Are you ISA or certified landscape planner? Those are the two categories. If you are, do you have a document saying in your professional opinion it's dangerous? That's the end of it. That was quite literally the end of it. What happened is once this legislature, I mean, this is our interpretation of petitioner's interpretation, saw how open it was, there was the sausage making, the legislature continued, and the next year they narrowed it, they tightened it down.
And I want to hone in on that. It's not an argument that's like before us, but it's so glaring and you can't ignore it, which is this amendment that came along not too long after the events that we're dealing with here under the earlier version of the statute, this amendment, you would concede as amended, if the same case came up now, that the mobile home park.
100%, yes, Your Honor. And the reason is the resident, there's a three-part amendment. The first part says residential homes have to be single-family detached houses.
So does that subsequent, this is kind of an interesting area of law, does that subsequent amendment offer any clue as to legislative intent on the earlier version of the statute?
It does, but it's not governing. Of course, the plain and ordinary language of the original statute is so much more, I think, powerful in leading a court to interpret the statute. I think secondary, I think if there was ambiguity about the original words, that legislative history would provide evidence for one or another. But I think really the plain language should be the governing.
How can we find a departure of the essential requirements of the law when the trial court here followed the correct law, which was Vickery at the time?
Well, it's petitioner's argument that they did not follow it, because what they did is they took.
They did follow it. You're saying that they followed it incorrectly.
That is correct, Your Honor.
I'm really not seeing the distinction there and how that's a departure from the essential requirements of the law.
So
They followed it to a T. And you're saying they shouldn't follow it to a T. They should have seen some variation because there was an actual deal on the position before.
respectfully, Your Honor, I disagree that they followed it to a T, because what they did is they said this is the ceiling. It's not zone residential, so it can't be residential under the statute. Not zone residential, so it's not residential, versus saying,
That's what
okay,
this application of the law. That's all you're saying, all you're doing is reframing what Judge Smith just said, well, they misapplied Vickery, but we know in second tier cert, that's not even enough.
well, first I would say, Your Honor, a misapplication of the law to a set of facts under Kakalanos, which is a Supreme Court decision I cited in the case, is enough to grant petition for certiorari review. So not just the interpretation statute, but even the application of the statute to a set of facts, if it's incorrect, this court has discretion to accept or to grant certiorari, and that's in Kakalanos. And of course, that was a momentous case when it was decided in 2003, in clear ambiguity about when second tier review, when a petition would be granted in this case. Secondly, I would say they fundamentally misinterpreted the term residential, which is really part of the statute. If it's residential property, all this applies. If it doesn't, it doesn't. What they said is it's not residential property. And so that is really in many ways applying the
You're
wrong.
saying they, are you referring to Vickery or are you referring to the trial court?
Only the trial court. I believe Vickery was decided correctly. I think the interpretation of Vickery is incorrect.
Well, are you saying that Vickery read in a word that's not in the statute, the word commercial?
Vickery is towards the end of the opinion, and I can cite it for you. I believe it's 250 on 255, which is page 255, halfway down. They say we reject the city's contention that this statute does not apply. Residential property is property zoned for residential use or in areas that have no meeting property used for the same purposes as property zoned for residential use. So they're describing
Regardless of the zone.
regardless of the zone. Well, they're saying, by the way, there's some cities that don't have zoning. For example, Cedar Key, Florida has no zoning. So there are a few that don't have it. And so for that reason, if there's no zoning, you can still look and say, is it predominantly residential? And it would apply in that case, this original statute. Because
Isn't that by its holding cover both instances, whether property is zoned or whether property isn't zoned? I'm really trying to figure out, is there a third instance you're going to tell me that they should have followed, other than the trial court should have gone on its own and said, okay, that's not enough?
the appellate,
The
the local circuit court actually quite literally dictates that if it's not zoned residential, it wouldn't apply. That's why Gandy, that one of the two properties that we originally appealed on, first tier review, they said it wasn't residential, simply because it was not zoned. That was essentially the crux of their argument.
That's what Vickery said.
What Vickery says doesn't say if something's not zoned, it can't be residential. It just says something, it's really the inverse. It says if it's residential, it's
We
obvious.
have that situation here where the one property is commercial.
Say again, Your Honor, I apologize.
But do we have that instance here where the one property is commercially zoned? So-
No, Your Honor, because in this case, the commercial zoning is dissimilar from Vickery. There was no commercial zoning, it was home, just a home in that case. So that, it makes it different in that sense, but that is the only court that's interpreted the original statute in the state of Florida, or ever will, arguably, other than this one, because of the statutory change.
I'd like to clarify one thing. Do we have here a situation where this mobile home park had whatever zoning it had 40 years ago, let's say? The land use, the comprehensive land plan changes, overlays commercial now on this property that didn't need commercial to be built. So the city is saying it's on commercial, we have a different set of standards. We're not gonna go back in the 50s or 60s and say it's residential. We're not gonna believe our lies and say they're using it for residential. We're gonna believe zoning map that rules all. Is that what happened in this case?
So, Your Honor, that's how it was looked at. They didn't really take any action. The city rezoned it actually in the 70s, did nothing. The FLU map, the future land use map, allowed residential and allowed mixed commercial, which would have been residential commercial. So it was never really a situation where the city was trying and taking effort to make sure there was no residents
They're
there.
trying to make it simple for you, for them, for their workers, but on the other hand, maybe they oversimplify to your detriment. That's what you're saying.
Absolutely, they constricted the statute, they constricted it, and so the legislature purposely, our case law shows that when the legislature leaves something open-ended, it should be interpreted in a more broad way. The circuit court came in and constricted the meaning, saying no, it only means residential if it's zoned that way, and so they actually wrote the legislature. The legislature, of course, through the amendment that came later, could have chosen to make it more narrow. In fact, there's things in the original statute that are very narrow. For example, the person that's allowed to give documentation, say you can remove a tree, it says you have to be ISA certified, you have to be a Florida landscape plan, very specific. Then they get to the residential part and they say, document residential land, remove a dangerous tree. It doesn't even define dangerous. And so it was obviously, if you just look at the statute, you have specificity there and you have broad open-ended terms in there. And so I think that, under Florida case law, courts should interpret those legislative terms in a more broad way, not an ambiguous way, but definitely broad. That's the crux of it.
That was one thing that troubled me about this, is that, that is residential property, in Florida, can be potentially very, very broad. If you were writing the opinion, what would you say how a trial court is supposed to? I would say, Your Honor, that it has to be interpreted reasonably, and what reasonably means that what the average person thinks with residential property. For example, walking down the street, looks at property, say, yeah, that was residential. The average person of reason who would look at a set of condos and say, hey, even though that's under some LDR code that nobody in this society, other than a few, folks, they know that's residential property, no matter what it says underneath. And of course, that's why the legislature came in later and said, hey, mobile home lots, condos, apartments, all these things, we want to change the meaning, just restricted to single lot building houses. So.
You want your 5 minutes?
Yes, thank you, Your Honor.
Morning, how are you?
Good morning, Your Honor. Nancy Cord. From the background perspective of this property actually has always been commercially zoned, and never been anything other than commercially zoned. And what was presented before the special magistrate, the code enforcement here is the fact that this particular down as a campground, obviously a commercial purpose, commercial use. And at some point morphed into what more
Flower in the mobile home park.
Correct, and which is a non-conforming, non-allowable use. What we put forth before the magistrate is that even though this may have existed over the period of time, there was never a sanction by the city.
With blue maps and the future land use maps, were those admitted at the initial hearing?
No, Your Honor. The future land use maps did not come into what Miller and Sons presented through their attorney's hearing. Were just the aerial photographs of approximately 40 something. The historical photographs that were typically showing that as at some point it morphed from just being originally a commercial campground to people living on the residences. And this isn't the same as, say for instance, a mobile home park where people own the small piece of land and also trailers. It literally was being used commercially, as in these mobile homes were there, they're being rented, I believe 2 on each side. So it is used for, it had never been officially sanctioned by the city of Tampa. In fact, we had the zoning administrator talk about that there is a process at the city of Tampa that if you have a non-conforming use, that you can come to the city and get some type of blessing or sanction for that particular use. That never happened in this particular case.
So this is all about the failure of the tree guy to get permits. When a permit was required, for whatever reason, presumably it was a commercial use in the city's opinion, correct?
From the property had always been zoned commercial. In fact, the city's code went so far as to say that even if this really was what you would say a mobile home park, it wasn't allowed on the property that it was on. They were meant to be in special districts, and this was not that particular district. This wasn't that big piece of property.
So going to opposing counsel's argument, it seems like your argument really is that if it's not zoned residential, it's not residential for purposes of 3045. Is that a fair assessment?
A fair assessment, but Vickery pretty much puts it there. The property is zoned commercially. It's being illegally used in some purpose.
Sure.
And it was not residential in the sense of what the statute said. And the way that the statute's originally written, 163045, it excludes, it doesn't use the word property. It doesn't use, as just a general property. It doesn't use the word use. It says residential property because in the Florida statutes that has a special connotation when you're talking about residential versus commercial. So using the word residential property.
So you've smuggled in the word zoned residential property, which wasn't in that version of the statute. And let me cut right to the chase. Is what's troubling me about this case, and kind of echoes a little bit about what opposing counsel said. Under the facts of this case, an empty vacant lot that happened to be zoned residential is quote unquote residential property for purposes of the preemption statute. But property that has been openly used by mobile home park residents for decades isn't because of how it happened to be zoned. Help me through why, just under the plain text of what residential property is, that anomaly is perfectly okay with it.
In this particular instance, the more, and I'm not certain what the parameters are, but the classic example is what this property is right now in 2023, which is a car wash. So that is it is currently Woody's Car Wash. And that is the distinction, is that this property,
It was used as maybe for residences, but it is
commercial, and that's borne out by what it is right now in 2023. And so it kind of turns the statute on its head if you say that if it's commercial, we're just going to look at whether or not people can live on the property, because that's just not enough. And in this particular instance, some of the background that the special magistrate got was the fact that this property had been up for a rezoning application that got denied in large part because of the number of trees that needed to be removed. This statute comes 3 months after that zoning had been denied, and all of a sudden, the trees are just basically 30-something trees, but of course the only ones we focus on for the city are grand or protected trees, are just a large swath of trees just cut down to make way, not for the danger that the legislative history was talking about. Because if you go far enough back in that legislative history, it's talking about I believe this came about right after Hurricane Irma, I believe. And so the initial versions of this bill are talking about what private property, residential property owners can do when you're dealing with issues like in a hurricane, and how fast you need to either deal with the danger, etc.
I don't know that we can, the Florida Supreme Court has been pretty clear about whether or not we should be looking at legislative history. There are other pieces of history as to why this preemption statute came about that, and we could really go deep dive in that, as far as residential lots with a brand oak and built, never been built on, things like that. So there's a lot of history out there, but the Florida Supreme Court is pretty clear, we're not supposed to get too far into that. We're stuck with this version of the statute that says residential property. And I hear what you're saying, I mean, I think what you're suggesting is that part of the existential character of whether or not it's real property or not necessarily is what can you use it for?
Correct. Correct, and in 2023 or say for instance, the property was completely vacant and they wanted to take these trees down, you could not have legally put up a mobile home park or RV park or anything where people could actually own the land and live there. That would not have been something that would have been legally allowable. It's just as a process, as a happenstance of where things developed and morphed from this commercial campground into this. And that's not what this statute was contemplating.
Got one more question, Brad, I'm not taking a lot of time, that this concerns, council's argument about whether they got, whether the trial court, whether the circuit court sitting in review capacity, erred in how its view of Vickery is, and then you could read, according to what Justine said, you can read Vickery as basically saying, hey, look, on the facts of this case, it's zone residential done. The analysis ends there, without saying that purports to create a thou shalt have residential zoning rule. So there's that, but there's a troubling footnote in the circuit court's ruling that I read that seems to delve into what was motivating the court's reasoning. And that's where the court says, and I'm reading here, the statute's reference to quote a tree presents an interesting view here. Whether one can draw any conclusions as to the legislature's intent to limit removals to a single tree, it at least suggests that mass removal of trees was not intended by the statute. The circuit court's doing there is construing the indefinite article A as if it means one, and that is simply incorrect as a matter of law. That's just bad interpretation. That's clear.
But the fact that it's in a footnote, I don't know, the fact that it's in a footnote, I would suggest that it's, it doesn't control, it's just maybe a thought process that the court was having, and perhaps the court had that thought process because it was an issue that did come up below, in the hearings before the special magistrate. That did present an issue. We did research that issue. We did talk to the magistrate about the fact that we believe that as long as there was documentation as to each tree, that was sufficient, even if it ultimately resulted in a large swath of trees going, that if that documentation and if it met the property characteristics and the arborist was willing to save for each single tree, that's what happened. And essentially the arborist in this case at least tried to
I'll tell you,
go tree by tree.
My concern with that reason I bring it up is if that footnote had been elevated and were in fact reason of the court, I think it would be a pretty close case of there being a departure from the central requirements of the law. Because again, that is just a misconstruction of the function of the indefinite article A in statutory interpretation.
But it's curious.
My follow-up is, if we say Vickery does apply on its face, it's clear, it's not a clear departure from the central requirements of the law, there's no irreparable harm. This goes back for a trial?
No, Your Honor, this actually, the trial court sitting in its appellate
This is
capacity,
the end.
it will be the end of it.
So he
And
doesn't get to litigate all these issues we're talking about today, about mass removal, one removal, history, use, etc.
correct, Your Honor, this, if you affirm, and obviously the city's asking that you affirm the trial court's holding or circuit court's holding, but if you do that, at that point, it just finalizes the ultimate decision of the special magistrate in 2020. And then at that point, the city would the code enforcement process would continue as far as solidifying the judgment in the
About
case.
30 different permits, let's say, that he didn't get, that you claim he should have gotten, that's talking about quite a bit of money.
Yes, Your Honor, I believe the total fine that was imposed upon the company was approximately $234,000. So that if you affirm, then certainly at that
That's
point,
the end of the line.
it would go back to the court enforcement magistrate to finalize these particular issues and then go through the regular code enforcement process as far as filing liens.
You know your stuff, I give you credit for that. These regulations are mind-boggling, aren't they?
Yes, Your Honor.
Well, you have a few minutes left. You want to keep going?
No, that was it. The only other thing I would say is what I was saying earlier, which was just, as a final point, that the argument about this just being a floor as opposed to a ceiling is inapplicable here simply because we're in the city of Tampa. The city of Tampa's rules before Vickery came along, or excuse me, before 163.045 came along, were the rules and are the rules that control how we look at property in the city of Tampa. The city of Tampa does have very extensive zoning, and here, these properties have been given particular characteristics or names or zonings. So that whole issue of or land that's used in a particular, it doesn't matter here, because in the city of Tampa, we have said that 3011 Gandy is commercial. And that the other properties that were involved, that they are residential, and that's the end of that inquiry here. So we don't have to look at whatever the ceiling is or these amorphous other characteristics we can read into the property. We have given these pieces of property their names, their designations. We've also said what can and cannot be done on these pieces of property. And that in this city is what controls the zoning controls in the city of Tampa. And as it relates to the statute and the way that Vickery has interpreted, this property is commercial. A permit was required to remove those grand or protected trees. And we ask that you affirm the circuit court's decision in this case.
Thank you. So you ready for 5 minutes for rebuttal? You do have 5 minutes.
Thank you, Your Honors. I just want to point out one more thing about Vickery and why I think Vickery was misapplied in this case, why the incorrect law was applied. And so therefore, the essential requirements of law were departed from. And that's because in the sentence in which Vickery talks about defining residential, it says, well, in this case, you have resident property, the statute applies. Quite literally, this is what was motivating the court. This is why the application in this case is so wrong. The next sentence in Vickery, after it defines residential property, says, going against what the circuit court was declaring in that case that they actually overturned, it says, to hold otherwise, well, I'll just repeat the whole thing. Residential property is property zoned for residential use or in areas that no zoning property used for the same purposes as zone property or just has residential use or for residential use. To hold otherwise would ignore the terms common use and improperly limit section 163.045. So what they're motivated by, one of the things that's animating them is saying the court that they were reviewing is trying to improperly limit the interpretation of this purposefully drawn broad statute. I mean, it's purposely drawn that way. And the court was trying to limit it. And they're saying we don't want it limited. And so by, the circuit court of the 13th Circuit Court in its appellate division, applying it, it's doing quite literally exactly what the circuit court that was being appealed in Vickery was doing, which is improperly limit the statute. And that's just, it's just
You're
quite
basically
literally.
saying there is a big departure from the law, although a case uses similar words and it's similar to your case, is clearly different. We've got to figure, that's on us to figure out.
Very much so, but the most important thing here is that Vickery applied the term residential to a set of facts, but definitely no way should it be construed as saying there is no other property that could be considered residential that's not zone residential. And so that's why it's the essential departure from the law, Your Honor. And we ask that the petition be granted and the order below be quashed. Thank you.
Thank you. Well, thank you both. You did an excellent job. We have one more case on the oral argument docket. That's the Surgery Partners versus National Union Fire Insurance.